Hey everybody, welcome back. Do you know your rights? I mean, hopefully you're never in a situation where you need to know your rights, but let's go ahead and know them anyway. Smash that like button and get your notes ready. Due process is mentioned twice in the Constitution, in both the 5th and 14th Amendments, which collectively tell us that neither the federal nor the states can deprive a person of life, liberty, or property without due process of law. More specifically, this topic deals with procedural due process, meaning that laws must be applied fairly, and legal processes can't be arbitrary. In other words, there's a set of rules that applies to everybody the same, and those rights can't be violated. This section is all about the 4th through the 6th Amendments, which can broadly be described as the rights of the accused. First up, the 4th Amendment protects people from unreasonable searches and seizures. Of course, what is a reasonable or unreasonable search is a bit subjective and has been debated over the years. So, when exactly can an officer legally search somebody? The text of the 4th Amendment helps us to answer this question, as well as reminding us of the purpose of the 4th Amendment. It begins by acknowledging that we have a right to be secure in our persons, houses, papers, and effects. In other words, all our stuff, from unreasonable searches and seizures. In this context, seizures means to take something. So we can't be searched or have our stuff taken away from us by the government unless a warrant has been issued, and the only way to get a warrant is by probable cause. So for a search to be legal, at least one of three things has to be true. The officer has a search warrant, they have probable cause, or they have consent. A search warrant is a legal document authorizing a search and describes exactly who or what can be searched. Probable cause is a little more frustratingly defined as a good reason to believe a crime has been committed. To get a warrant, an officer needs to convince a judge that she has probable cause, or PC if you want to sound like you're on Law & Order. Sometimes a situation is moving too quickly to wait for a warrant, so the officer uses their own judgment on whether a judge will agree that they in fact had probable cause when they made their search. That third reason, consent, is all about the person being searched. If they agree to the search, they've given their consent, and it doesn't matter if the officers lacked a warrant or PC, the search is legal. And the Supreme Court has held that officers can lie to a suspect to convince them that they have to consent to the search. So make sure you know your rights. You've probably noticed the recurring subjectivity with 4th Amendment issues. Ultimately, police and judges are guided by Supreme Court precedent when deciding whether something is reasonable or an unreasonable search. And we know the Supreme Court changes and evolves over time. So there isn't a one-size-fits-all answer to the many hypothetical or one-off situations we can dream up. The reason this all matters so much is because of the exclusionary rule, which says that illegally obtained evidence cannot be used against a person in their trial. It doesn't matter how good the evidence is or how guilty it makes the person appear, it's inadmissible in trial if it was collected illegally. Admittedly, this rule can be controversial, so let's spend a moment discussing it. First, the argument for. Without the exclusionary rule, the 4th Amendment doesn't really mean anything. But by ruling illegally obtained evidence inadmissible, it really puts the onus on law enforcement to do their job without crossing that line drawn by the 4th Amendment. In other words, this rule is designed to protect the rights of the accused. On the other hand, some argue that this goes too far and that it makes law enforcement's job more difficult and that it allows some guilty people to get away with crimes they committed because of a technicality. And it is true that this happens at times. Not to get too philosophical, but here's what it comes down to. Like Madison pointed out, and all our experience shows, people are not perfect. Therefore, any human-made justice system will also be imperfect. Then the question becomes, if it's going to make mistakes at times, and it will, what's the better mistake? Is it preferable to catch as many guilty people as possible, even if that sometimes means violating the rights of the innocent? Or is it better to safeguard everybody's rights, but sometimes letting a guilty person go free? There's not an objectively correct answer to these questions. They're up to each one of you. It all comes back to the big idea of this unit, how to best balance liberty and security. The Supreme Court has limited the exclusionary rule over the last couple of decades. One limit is called objective good faith, meaning that if the officer believed that the search is legal, then the evidence can be used in trial even if it was obtained illegally. Most commonly, this could be due to a piece of inaccurate but possibly trivial information on the search warrant, perhaps a misspelling of a name or a street number. The other is called the inevitable discovery rule, where the court has said that if the evidence would have eventually been found anyway, that it can be used at trial, even if it was obtained illegally. There's a little more gray area in this one. Recently, the Supreme Court has ruled that warrantless searches of cell phone data are unconstitutional. So they can't just look at the pictures on your phone or your texts or whatever without a warrant. And the court and Congress have placed limits on the bulk collection of telecommunications metadata. This is often referred to as mass surveillance, and in the aftermath of the Edward Snowden revelations, new limits were placed on the collection of this metadata, and there were rules put into place requiring agencies to get warrants to examine metadata. We're thinking of things like your call and text history and GPS location history. Speaking of protecting the rights of the accused, the Sixth Amendment guarantees the right to a speedy and public trial with an impartial jury of your peers, and legal counsel if you can't afford it. One of your required cases, Gideon versus Wainwright, was a landmark ruling that incorporated the right to an attorney, meaning that now states must provide defendants with legal counsel if they can't afford it. As all fans of 21 Jump Street are undoubtedly familiar with, we also have the Miranda Rule, which requires police to inform suspects in their custody of their Fifth and Sixth Amendment rights. It doesn't actually establish any new rights, it just says that suspects must be informed of their rights. There is an exception, however, known as the public safety exception. If police ask a suspect a question to neutralize a dangerous situation, a statement made by a suspect can be used as evidence, even if they haven't been informed of their rights. This came as a result of a case where police were chasing a man through a grocery store, and when they arrested him and asked him where the gun was, he responded. Even though he hadn't been informed of his rights, the court held that the question did not violate his rights because the public safety was at stake, and he answered voluntarily, so his response could be used as evidence at his trial. Again, for this whole lesson, keep in mind the big picture idea of balancing liberty and security, and definitely be able to identify policies that are aimed at either of those goals. Alright, well that's it for this one. Until next time, this has been a LaMoney production. Thanks again for watching. I hope that you are having a great day and this video helped. If you want to help me out with our YouTube overlords, go ahead and smash that like button. You know I appreciate it. And I will see you in the next video.